What happens when the bedrock of a nation's legal system is challenged not by an external enemy, but from within its own government? In an era defined by political polarization, where does the ultimate authority lie when the executive branch and the judiciary collide? We witnessed a startling confrontation that cuts to the very heart of this question. In a high-stakes congressional hearing, Representative Khanna, a Democrat from California, faced off against Pete Hegseth, the United States Secretary of Defense. The exchange began with a discussion on foreign policy and the looming threat of war with Iran, a topic rife with its own tensions. But it quickly pivoted to a far more fundamental issue: the rule of law on American soil. The senator posed a simple, direct question regarding a domestic legal dispute, expecting a straightforward affirmation of judicial authority. Instead, he was met with a series of evasions that raised profound concerns about the administration's commitment to the separation of powers. This wasn't just a policy debate, it was a test of allegiance to the Constitution itself. What does it mean for the future of a democracy when a top defense official refuses to pledge allegiance to its courts?
Common ground, no war in Iran. In 2016, President Trump was one of the few people on the Republican stage to have the guts to say that George W. Bush's war in Iraq was an utter disaster. He promised the American people no endless wars. Tucker Carlson has said that thousands of Americans will die if there's a war in Iran. And he is cautioning that currently neocons are trying to get President Trump into a war in Iran. Representative Marjorie Taylor Greene has said the American people don't want to bomb Iran. Will you today assure the American people and the MAGA movement that you will not bomb Iran unless we are hit?
Congressman, it's good to hear you quoting conservatives.
When they're right, I quote them.
I will tell you this. The president has been earnestly and completely committed to a peace process, has given Iran every opportunity, those talks ongoing, but he also fully recognizes the threat that Iran with a nuclear weapon would exist.
Will you commit to us not bombing them? I mean, that's what the conservative MAGA movement is calling for it online. You'll see. I mean, they want a commitment that we not bomb Iran unless we're directly hit.
Well, here in this forum, it wouldn't be prudent for me to commit or not to commit. My job is to be postured and prepared in the region, just as the chairman.
How about this?
For any potential capability.
Would you agree with this analysis that Netanyahu is itching for a fight? If Netanyahu uses American missiles to hit Iran, he's going to drag us into a war there because Iran's going to say they're using American missiles. Our military knows that you cannot just through hits eliminate Iran's nuclear capability. They'll simply go underground, and they will then end monitoring. And unlike Iraq, they're in heavily civilian sites. Will you stand up today and make it clear to Netanyahu that that escalation, what he's threatening just yesterday, is not in the American interest, that he should not be dragging America into war with Iran?
Well, Congressman, that question included a lot of speculation. What I know is that Bibi Netanyahu is going to put his country first, and we're going to put our country first, and we're positioned properly in the region to ensure that we're prepared for any potential contingency.
Are you concerned about his escalation into Iran, and will you assure the American people you're going to do everything possible to keep us out of a war in Iran?
We remain, as the president has said, committed to creating the conditions for peace, creating the conditions for talks where Iran does not have the ability to develop a nuclear weapon.
I'm running out of time, 2 minutes, so let me ask you another matter. Senator Baldwin asked you about the legal authority for the Marines in my state. I disagree with you. I thought not only do I not want Marines in Iran, I don't want them in California. But I don't want to get a gotcha. You know, they said, what provision? Your administration since then has filed in the federal district court. You're arguing that the Marines should be allowed to defend federal property. I disagree with you. That's your argument. Here's where I hope we can agree. Whatever the federal district court decides, will you abide by it?
Well, this is a pending, pending situation.
So will you agree, though, that it's not my legal view, it's not your legal view that makes the decision in America. It's the federal judiciary. If the federal court in California and the San Francisco district judge has orders a preliminary injunction, will you agree to abide by the federal courts?
What I will tell you is my job right now is to ensure the troops that we have in Los Angeles are capable of supporting law enforcement in there.
Sir, I agree with that, but will you?
And we know we have the
just assure?
constitutional and statutory authority
That's fine, but
to do that.
can you just assure us that you'll abide by the decisions of the courts?
We've always looked at the decisions of
Well, the Vice President has said that he doesn't believe that the courts should be respected in military matters.
This is not my lane, but we also recognize that the way in which the judiciary has expanded its powers.
But can you
during
just give
the
a
Trump
simple?
administration
Okay,
is
let me
quite
ask you this:
clear.
two simple questions. You got 30 seconds. I'm not trying to trick you. I think it would assure the American people, because it shouldn't be Ro Khanna's view of the Constitution. It shouldn't be Secretary Hegseth's. It should be the Supreme Court and the federal courts. Can you assure the American people on two things? You will respect any Supreme Court decision on this matter about whether the Marines are constitutional, and you will respect the district courts when they rule before the Supreme Court rules.
What I can say is we should not have local judges determining foreign policy or national security policy for the country.
So you're not willing to say you would respect those decisions?
What I'm saying is local district judges shouldn't make foreign policy for the United States.
Gentleman's time's expired. Chair now recognizes the gentleman from Mississippi, Mr. Kelly.
Thank you, Secretary Hegseth.
In the theater of politics, a congressional hearing is a stage where power, ideology, and accountability collide. The exchange between Congressman Ro Khanna and Secretary of Defense Pete Hegseth serves as a masterclass in the art of strategic questioning, revealing not only the policy positions of an administration, but its fundamental governing philosophy. Khanna's performance was not a random series of inquiries. It was a meticulously constructed interrogation designed to expose a critical vulnerability. His central thesis was that the administration, represented by Hegseth, harbored a dangerously dismissive view of judicial authority, placing its own judgment above the rule of law. The progression of his questioning was both logical and relentless. He began on what he calculated to be common ground, preventing a war with Iran. By citing President Trump, Tucker Carlson, and Marjorie Taylor Greene, Khanna cleverly framed his opposition to war not as a partisan stance, but as one aligned with the very base of the administration's support, the MAGA movement. This initial gambit was designed to disarm the witness, forcing Hegseth to either agree with his own allies or contradict them. This use of evidence was a strategic choice to establish a baseline of reasonability before pivoting to the core of his argument. The true objective was not to debate foreign policy, but to test Hegseth's commitment to the American system of checks and balances. Having set the stage, Khanna transitioned to the domestic issue of Marines being deployed in his home state of California. Here, his questioning became laser-focused. He was not interested in the merits of the deployment, but in a single vital principle. Would the administration abide by a federal court ruling on the matter? This question was the linchpin of his entire strategy. He wasn't seeking information. He was seeking a public affirmation of a core democratic tenet. The strategic goal was clear: to force Hegseth into a public choice between affirming the supremacy of the judiciary or revealing a belief that the executive branch could operate outside its constraints. This was a direct challenge, designed to create a moment of undeniable clarity for the public record, laying bare a potential constitutional crisis. Khanna's tone throughout the exchange was a study in controlled prosecutorial pressure. He remained calm, measured, and relentlessly on message. His language was precise and legalistic, employing terms like federal district court, preliminary injunction, and abide by. This choice of words was deliberate, framing the conversation not as a political squabble but as a matter of legal principle. There was no overt aggression or theatrical outrage. Instead, his demeanor projected an air of serious, intellectual inquiry, which made Hegseth's evasions appear all the more glaring. This calm persistence was a strategic tool. It kept the focus entirely on the substance of the witness's non-answers, preventing Hegseth from dismissing him as a hysterical partisan. The power of his performance lay in its restraint. By refusing to become emotional, he forced the audience to confront the cold, alarming logic of the secretary's position. This created a powerful contrast. The questioner, calm and insistent on constitutional order, versus the witness, deflecting and unwilling to commit to that same order. The strategic impact of this demeanor was profound. It lent immense credibility to his line of questioning and painted the witness's refusal to answer as an unreasonable and radical departure from American norms. For the public watching, it wasn't a shouting match. It was a clear-eyed examination of a deeply troubling philosophy of governance. Perhaps the most masterful element of Khanna's approach was his adaptation to Hegseth's responses. He anticipated evasion and had a clear strategy for countering it. When Hegseth first deflected the question about bombing Iran by calling it a good thing to hear him quoting conservatives, Khanna immediately steered it back. When Hegseth offered the vague assurance that the president was committed to a peace process, Khanna cut through the noise with a direct follow-up. "Will you commit to us not bombing them?" He refused to let the witness change the subject or hide behind platitudes. This pattern intensified when the topic shifted to the judiciary. Hegseth's initial response that it was a pending situation was a classic delaying tactic. Khanna countered not by arguing, but by rephrasing and simplifying the principle at stake. It's not your legal view that makes the decision. It's the federal judiciary. He was breaking the issue down to its most fundamental component. When Hegseth continued to evade, offering only that his job was to ensure the troops are capable, Khanna pressed harder, narrowing the question to an inescapable binary choice. He asked for a simple assurance that Hegseth would abide by the decisions of the courts. Hegseth's response, "We've always looked at the decisions of the courts," was another masterful piece of non-commitment. Khanna immediately identified the weakness in this, citing the vice president's contrary statements to show this was not a settled issue. Finally, he cornered the secretary with his last question, a simple two-part request for an assurance that he would respect both the Supreme Court and the lower district courts. Hegseth's final answer, "We should not have local judges determining foreign policy or national security policy," was the admission Khanna had been working toward throughout the entire exchange. He had successfully controlled the narrative, stripped away all layers of bureaucratic jargon, and forced the secretary to state on the record a view that places the executive above the judiciary. The confrontation laid bare a fundamental schism in American governance. The question posed at the outset, what happens when the rule of law is challenged from within, was answered with alarming ambiguity. Secretary Hegseth, in his refusal to give a simple yes to respecting court orders, provided a chilling insight into a worldview where executive power, particularly in matters of national security, is seen as paramount and potentially unbound by judicial review. This was not a failure to answer a question. It was an answer in itself. It suggested a belief system where the checks and balances that define the republic are not sacred principles, but inconvenient obstacles. Khanna's interrogation demonstrated that the most significant threats to a democracy do not always arrive with a bang, but sometimes emerge quietly in the careful, calculated evasions of a witness under oath. The exchange forces us to confront a terrifying possibility that the very institutions designed to protect the nation could be guided by individuals who do not believe they are accountable to its laws. What do you think about this issue? Does the executive branch have the right to defy court orders in the name of national security? Leave your comments below, and don't forget to like and subscribe for more in-depth analysis.